what are the issues you consider for litigation? Let's say internal dispute resolution didn't work or you didn't do it. Alternate dispute resolution didn't resolve the issue, and now you're ready for litigation. The first thing I want to talk about is the causes of action you might want to assert in representing a property owner. The causes of action are breach of fiduciary duty, negligence, breach of the CC&Rs, breach of the other governing documents of the association that might be applicable. I mean, maybe you have a dispute concerning architectural regulations. That may be a breach of those. Another cause of action might be a violation of the Davis-Sterling Common Interest Development Act. That's in Civil Code Section 1350 at SEC, and that's the primary body of law that governs homeowners associations. And it spells out a series of laws that apply to homeowners associations, and if you work in this field, you have to be familiar with those particular statutes. Now, the remedies sought could be monetary relief, declaratory relief, injunctive relief. It could even be specific performance under certain cases. Now, one issue that comes up frequently in litigation is whether or not to name the individual board members in addition to the association. And generally, my advice is that you don't name the individual board members. And the reason for that is that individual board members have some limited immunity from liability created under the law. And if they acted in good faith and reasonably and with in their best business judgment, they can be relieved of liability, whereas the association as an entity doesn't have the same defenses as the individual board members. Also, usually if the board member is acting in the course and scope of his duties as a board member, there's no liability. I frequently tell my clients, if the board member is making a decision as a board member to do or not do certain action, that's usually not actionable. However, if the board member steps off the podium where he's sitting and walks up to the property owner and hits him in the face, then you might want to, then you have a basis to sue him personally. But in general, it's not a good idea, I don't think, to name the board members individually in these kinds of cases. For those reasons and perhaps some others. In the Rudder case I just described, you had an example of that situation where the property owner lost the case against the board members but prevailed against the association, and then you may have an issue about whether your attorney's fees are recoverable, whether the prevailing party, and the judge may rule differently for you than the judge ruled in the Rudder case because you didn't prevail on everything or most of the issues. Now, there are, as with every rule, there's an exception to the rule. There are some cases where it might be advisable to name the board members individually in the case, and that is in a situation where you have basically an alter ego situation, where the association has no assets, they're inadequately capitalized, they have no money in reserves. The insurance company either there's no insurance or the insurance company has denied coverage. All these things might give you a basis for pleading a basis to pierce the corporate veil. In those situations, you might want to name the board members individually. A question often comes up, should you name the property management company as a co-defendant when the property management company is the one you're primarily interfacing with? And unfortunately for property owners, there was a case decided a couple years ago that said that the property owner doesn't have a right to bring a direct action against the property management company. The property management company has no duties to the owner. The property management company has duties to the association. So the property owner could sue the association could then cross-complain against the property manager, but the property owner can't sue the manager directly for most things.